Supplemental list, item number 1.
In this case, you are directed in January 7 to take instruction with regard to amount which is lying in deposit and not been released to the parties because of the lack of sanction order. 2014, the deposit was made in page 39. Clarification was sought for in that page 39, and page 41 it was reminded again 2015, and still lying in deposit, not been released to the families, displaced families and the Kansbal project. They have been enumerated, the list have been submitted. The collector has repeated
the order dated 31/2025.
Yes, sir. Yes, fine.
Yes, sir. This case belongs to they have taken the instruction that there are 515 families they are identified and the code 38,000 amount has been given. But so far this 12 petitioner, the sanction has been made, but that is sent to the government for the appeal. So I pray,
whatever you want to say by way of an affidavit. So that
I pray, my lord, 1 week after. So in the meantime, we can take the if that will be sanctioned, then
none of the families have been paid.
No, paid se payment to hai no. Whether there are how many petitioners in this?
Well, they have filed in the representative capacity. They are representing 339 families of the village. 4 villages, 339 families.
When that sanction was sent for government approval?
As per the letter 7/6/25 of the land action officer, they are taking that 515 families, they are displaced families, their compensation has been paid on 4 crore 38,000.
That includes these petitioners?
No, my lord. So far, there are 12 petitioners. That is the 176 displaced families. They are for their purpose they sent to the government for sanction. So I pray 1 week after. In the meantime,
39 families.
I show
that. Page 39.
They have taken steps, sir. They have taken steps.
Nothing has been paid since 2014, my lord. Your lordship may just kindly have a glance to page 39 for a moment. Page 39. The collector has made a request. Page 39. It will be repeated in page 41.
No, the figure which Mr. Naik now comes up with, that is not reflected in this Annex 7.
He is saying something which is not there, my lord. This family has not been.
That is the recent one.
They have only
after 5 to 2014, that must be there.
No. This application has been filed 2021. Still, and nothing has been paid. All the 339 families, none of them have been paid.
This is 2025.
Yes, it cannot be just. Yes, that is very clear. चौदह इधर सही दिन से रिपीट कराई यथा करूं तथा करा
The lecturer was superintending engineer to the land acquisition officer. So what response this is a letter which you are.
It's a correspondence letter.
So what happened then? Any reply has been received from the
Ibbe. Puri din which
take down that in pursuance of the order dated 31/2025, according to the Land and Council for the state, letter has been issued by the Superintending Engineer Raurkela Irrigation Division Raurkela, dated 7/3/25 to the Land Acquisition Officer Sundargarh, wherein it is stated that after discussion and verification of the record, it is ascertained that 515 families have been identified as displaced families in the Kansabahal medium irrigation project Sundargarh, and compensation, R&R compensation amounting to 4,38,89,000 have already been deposited with the LAO Sundargarh for payment to 176 displaced families. And the land acquisition officer was asked to ascertain whether the 12 petitioners of this petition are included in the 176 displaced families for whom compensation has already been sanctioned, or if the said petitioners are in the list of 339 families for whom the compensation is to be sanctioned. Subparagraph. It is stated by the Land and Council for the state that no reply has yet been received from the land acquisition officer, and the matter may be taken up 2 weeks after, so that he will apprise this court about the latest development. Put up this matter in the week commencing from 21st April 2025. If you let us have a copy, that is for looking
May I submit, madam?
Yes.
These 12 petitioners, they represent 339 families. None of the 339 families have been paid.
Mr. Naik, you should get the instruction from opposite party number 7, because that letter is addressed to opposite party number 7. He is to now reply. If you ask the other persons, they cannot.
Collector saying that give us a sanction order so that I can release.
This land acquisition officer को bracket लिख दो तो opposite party number 7, and superintending engineer party is
Chief engineer,
chief engineer.
executive engineer, chief engineer.
Yes.
Chief
हाँ,
post.
ठीक. Yes, next.
Item 2.
This is order 3/3/2020. Last of. My notes to have this matter. For similar person, they are granted the benefit miller.
Yes.
on the ground of belated stage.
Felicitor, another other person they are going to get benefit.
No, subsequent persons have also got the benefit
Yes, Lord, I have
that he passed the, produced the order, and the number we have reflected in the last paragraph of page number 2. That is one Mahendra Prasad Naik
yes,
and one Nalini Das. Their cases were disposed of on 2016 and 2017 also. So you are asked to obtain instruction with whether any challenge has been made to the order passed by the Central Administrative State Administrative Tribunal in those two ways. So what is your instruction?
I have instruction Lord. That the Mahendra Prasad Naik and Norinda as well as Dilip Kumar Naik, they are also getting the benefit.
So
So still, will you press this writ appeal?
So, why are you just discriminating in this way? You are paying some persons
Yes,
by the order of the.
Out of 12%, this 4%, with the except that person or 3% they are getting the benefit.
So that is the exact reason. So why are you pressing this?
The instruction will not.
Will that principle apply to this?
That's why I'm
Sir,
submitting
see,
that
if you
document.
give the benefit to a particular situated person in the department, the similarly situated person, you should so moto give them the benefit without
Everybody
approaching
need
this
not.
court.
ସେ ideal employer ର ideal state ର ଇଏ ହଉଛି ଜଣକୁ ଦେବେ ସିଏ ଖାଲି କୋର୍ଟକୁ ଆସିଲା ଶୀଘ୍ର ଟିକେ ପଳେଇ ଆସିଲା ତାକୁ ଦେବେ ଆଉ ଜଣେ ଟିକେ ଡେରି କରିଦେଲା ତାକୁ ମନା କରିଦେବେ. This is not the way. Everybody cannot have.
ସେଇଟା କଣ ସିନିୟରିଟି ଲିଷ୍ଟ ହେଲା କି ପ୍ରମୋସନ ହେଲା, that is matter different.
Instruction. Lordship may be passed or my lordship because of that.
No, the order is already in his favor. So the writ petition, you have filed this writ appeal, and the Learned Single Judge has already held page number 27 that in view of such position, the order dated so and so under Annexure 8 refusing to grant the benefit to the petitioner is hereby quashed, and the opposite parties are directed to pay such benefit to the petitioner at par with Kanchalwala Satpathy in terms of the direction given in the tribunal in case of so and so, the petitioner has been. So,
page 26 last তিনটা লাইনটা say, but while passing the impugned,
but not only indicated that see after not say
that is the only
ground.
ground.
How
For the sake of filing and not to grant.
Because you disposed for
So cost of
we are passing the order. As per the order dated 3/3/2025, the Learned Council for the state has obtained instruction from the superintending engineer, Rengali Dam Division, dated letter dated produced the letter dated so and so 17/3/2025 of the superintending engineer so and so, wherein it is stated that Mahendra Prasad Naik, Nalini Das, and Dilip Kumar Naik have been granted the benefits extended to Kanchanbara Sarkar. Stop. This writ appeal has been filed by the state of Orissa and others, challenging the order dated 29/11/2021 passed by the Learned Single Judge of this court in WPC OAC number 690 of 2013. The opposite party, no, this is the respondent. The respondent, Shraddhanjali Das, filed OA number 690 bracket C of 2013 before the State Administrative Tribunal, Cuttack Bench, Cuttack. Have you got that copy of that OA with you? Please pass on. Made a WPC, made a OA.
Sit. Sitting convert
এই নম্বর আছে ডব্লিউপিসি তারপর অটোমেশন অপরচুনিটি
সেটা আছে আমার ট্যাগ হিচ
এটা okay. To quash the order dated 5/11/2012, passed by the Principal Secretary to Government, holding that the prayer of the respondent to allow the benefit of postgraduate teacher post with effect from the date of her joining, that is 27/8/1984, being devoid of merits. Further prayer has been made in the original application for a direction to the petitioners, to the appellants, to allow the respondent the benefit of pay scale of postgraduate teacher from 27/8/84 along with its subsequent revised versions, and with a further direction to allow the benefits of pay scale attached to the post of junior lecturer with effect from 1/7/1991 and its subsequent revised versions. After the matter was transferred to this court, the what is that number?
ডব্লিউপিসি
WPC bracket OAC number 690 of 2013 was registered, and what is that order passed in the WPC.
59 is there, 21.
No, annexure. You have annexed that.
Yes, sir. Yes.
That's the
At page 21. And
21.
Start from 23.
ठीक है. And the learned single judge after taking note of the contentions raised by the learned counsel for the respective parties, has been pleased to hold that the rejection of the claim of the petitioner was on the ground that the rejection of the claim of the petitioner or the respondent was on the ground that the respondent approached the tribunal at a belated stage. It was further held that since the respondent stands on the same footing like Kanchan Bala Satpathy, the authority should have extended such benefit to the respondent. It was further held that approach of the respondent to the tribunal at a belated stage is not a ground not to extend the benefit to him, as the same is in violation of Article 14 of the Constitution of India. Accordingly, the order dated 5/11/2012 under Annexure 8 refusing to grant the benefit to the respondent was quashed, and the appellants were directed to pay the benefits to the petitioner at par with Kanchan Bala Satpathy in terms of the direction given by the tribunal in the case of Kanchan Bala Satpathy, to the petitioner as expeditiously as possible. When the matter was taken off on 3/3/2025, the London Council for the State placed the reliance in the case of State of Uttar Pradesh and others versus Arvind Kumar Srivastava and others, reported in 2015 1 SCC 347, and submitted that the respondent in this writ appeal was a fence-sitter and approached the tribunal after Kanchan Bala Satpathy got the relief from the government. After her original application was allowed, and the writ petition filed by the state was dismissed, so also the SLP preferred by the state. On that day, Mr. Sadasi Patral and counsel appearing for the respondent produced some orders passed in OA number 136 bracket C of 2013 in case of Mahendra Prasad Naik, which was disposed of on 16/11/2016. So also in OA number 138C of 2013 in case of Nalini Das, which was disposed of on 27/4/2017. The Land Council for the state was asked to verify whether the state of Odisha challenged the aforesaid orders passed in cases of Mahendra Prasad Naik, so also Nalini Das, before this court in any writ petition or not, and further to obtain whether the case of similarly situated persons are sub judice or disposed of by this court or not. Stop. Accordingly, the written instruction has been produced by the Land Council for the state today from the superintending engineer, Rengari Dam Division, which clearly states that Mahendra Prasad Naik, Nalini Das, and Dilip Kumar Naik have got the benefits extended to Kanchanbala Satpathy. Therefore, 4 persons have already got the benefit, and when it is not disputed by the Land Council for the state, Land Council for the appellants, that the respondent is similarly situated like those 4 persons who have already got the relief, merely on the ground of belated approach, the relief cannot be granted, a relief cannot be denied to the respondent. After going through the order passed by the Land and Single Judge, we find that there is no infirmity or illegality in the impugned order. Therefore, we are not inclined to interfere with the same. Accordingly, the appeal being devoid of merit stands dismissed.
The one payment.
Yes,
Directly implement the order.
no, that now it is dismissed. Now you are to take the next step, that there was already a direction to
Okay.
Item 3.
find that for the interest to say that in the period or the
So
needless to say that the time specified in the impugned order to pay the benefits to the petitioner within a period of 4 months from the date of communication of the order is already over. However, since the writ appeal was filed in 2022 and it is disposed of today, it is expected that the order passed by the Land and Single Judge shall be complied with. Complied with. Hello? Yes.
Kindly adjourn this matter.
Which one?
Because 1 month that my wife is also expired. So in the whitewashing time, I live somewhere.
Yes,
Sir, one month back wife expired ହେଇଥିଲି ତ
କାହାର?
ମୋର 41 years ରେ
No,
କ୍ୟାନ୍ସର
no,
ହେଇଥିଲା
କଣ, what do you want?
ବ୍ଲଡ୍ ରେ ମୁଁ ଚାହୁଁଛି ସାର୍ ଗୋଟେ 7 days
You want adjournment.
ସାର୍
What is your good name?
ସୂର୍ଯ୍ୟ ନାରାୟଣ ସାର୍
Mr. Suryanarayan Saul and counsel appearing for the petitioner seeks for an adjournment. You remove the defects as pointed out. Number of defects have been pointed.
yes sir
Put up this matter in the week commencing from 21st April 2025. In the meantime, the defects as pointed out by the SR shall be removed. Yes.
Item 4.
Please, madam. A disputed association filed one adjudication case before the RERA claiming compensation of rupees 30 lakhs against the builder. Your Lordship may have a glance to page 27. The relief sought for was
You want quashing of the order dated 25/2024 under Annexure 9.
mine.
It was
Mine.
it was passed in IA number 100 of 2024.
Yes, ma'am.
So while the main appeal was kept pending, one IA was disposed of. That is IA number 100 of 2020. What was the prayer in that IA? Filed an application under so and so.
My lord, I am coming to that. I'll clarify, my lord. The 30 lakhs was the claim. Adjudicating officer granted 50 lakhs. Despite the claim was 30 lakhs by the appellant, but the tribunal granted 50 lakhs. That was challenged in an appeal. And
Who is the appellant before the tribunal, appellate tribunal?
the present petitioner.
No, it's all right. Who is he? He is the about that project or कौन से director ना कौन?
Director.
Director. So why he preferred that appeal? Challenging which order?
Order, my lord. That is
Wasn't that
under annex,
real estate?
under annexer 5, my lord. Annexer 5. Annexer 5.
Annexure 5.
My lord.
It was passed by the adjudicating officer
Adjudicating officer.
Orissa Bhubaneswar in AOCC number 9 of 2022.
Should your lordship have a glance to the order,
In that
portion of order, page 191.
please wait. We have to, since we are hearing for the first time, we have to know the factual aspect clearly. So the complainant is one Captain Jayadev Patnaik.
Minor.
So you are the president representing that Bhuvan Pride Welfare Association Charitable Trust. So he filed this complaint under section 31 read with 71, right? For a direction to the respondent to pay 30 lakhs compensation with interest 12% per annum.
From the date of.
Right. From why he claimed that? Because what is the reason? Due to incomplete work, the flat buyers faced a lot of trouble and inconvenience
Yeah,
and
allege some
mental anguish
negligence.
and harassment for which the complainant has filed a claim. So you appeared and filed your reply, then the points were formulated, and so far as 1 and 3, the Learning Tribunal held okay. Paragraph number 18, page 190, para 18. From the above discussion, it is seen that the respondent has failed to prove his case. Consequently, it is held that the complainant has proved its case and the respondent has not provided the amenities and other things as has been
Would I place para?
just please read it out. Paragraph number 18.
18. From the above discussion, it is seen that
Hmm.
the respondent has failed to prove his case. Consequently, it is held that the complainant has proved his case and the respondent has not provided the amenities and the things as has been detailed in the complaint petition as well as agreement for sale. Due to non-providing of amenities as stated in the agreement for sale as well as the complaint petition, the alertees must have been suffering from harassment and mental agony in their comfortable living. As such, the term of Section 18(3) of the Act, the complainant is entitled to compensation. No guideline, para 19,
Yes.
no guidelines have yet been fixed either by the Honorable Apex Court or any other High Court, including our own High Court, relating to the assessment of compensation in case of present nature. Only Section 72 of the Act lays down some factors to be taken into account by the adjudicating officer while determining the quantum of compensation. For ready reference, Section 72 of the Act is reproduced below. While adjudicating the quantum of compensation or interest, as the case may be, under Section 71, the adjudicating officer shall have due regard to the following factors, namely the amount of disproportionate gain or unfair advantage, whether quantifiable, made as a result of the default, the amount of loss caused as a result of the default, the respective nature of the default, as such other.
Repetitive nature of default. Repetitive, not respective. Repetitive nature.
Sorry.
Yeah.
Such other facts which the adjudicating officer consider necessary to the case in furtherance of justice.
Hmm.
The complaint petition, the complaint has not assessed the amount of disproportionate gain or unfair advantage made by the respondent as a result of his default. Therefore, under this heading, compensation cannot be awarded. Similarly, the complaint petition is silent as to the amount of loss caused as a result of the default. So, no amount of compensation can be awarded under this head. At best, the case of the complaint would be covered under the category 72C of the Act. Considering the facts and circumstances of the case, mental agony and harassment as well as suffering by the alertees, I feel that compensation to the tune of rupees 50 lakhs would be the adequate compensation to be paid to the complainant, hence order.
So against this order, you preferred
Appeal
appeal before whom?
before the appellate tribunal.
And which order?
RERA appellate tribunal.
Which order was passed? That is,
My lord, actually, I filed a petition there to
no, now the order has been passed under Annexure 9.
9.
Annexure 9
Pending appeal.
is the
Pending appeal, this order is passed, which is impugned here
No,
in writ petition.
that is dismissed for non-payment of that fees, court fees. Because
Tribunal is
I
concerned
filed an
with it.
application, at least I should be allowed to pay court fees on 30 lakhs rupees. Because the prayer was for 30 lakhs, the compensation was awarded by the tribunal 50 lakhs. So my submission was the court cannot grant relief exceeding the relief claimed for.
Any decision.
By the appellate tribunal.
If that be so, applies to High Court, not a writ court.
It was the first. So this, by virtue of this annexure, passing this annexure 9, now the obviously the appeal has been disposed of
Yes, ma'am.
because you filed a IA and that IA was disposed of, and now the appeal is kept pending or it has been disposed of.
Disposed of, ma'am.
What is that?
You are aggrieved by Mr. Das. You are
Yes.
aggrieved by order dated 15/5/2024, passed by tribunal, appellate tribunal. Mr. Das, you are aggrieved by order dated 15/5/2024.
15/5, 25, 25, 25, 20. 25/24 in IA number 100 of 25.
Yes.
So this, you filed this IA for what purpose?
My lord, I have filed one IA
Yes.
for assessment of court fees. That is on 30 lakhs. That's statutory deposit. Since the relief sought for was 30 lakhs, so I filed one application that is annexure, the last annexure, my lord, and without considering it, this order was passed. My specific
Sir,
abandonment.
this is an order passed by an appellate tribunal.
Yes, ma'am.
So against this, you have a remedy. Have you checked up? Section 58 of the
58 says appeal to the High Court, not to the by way of a writ. It says appeal. So that is why we are asking you whether by virtue of that impugned order, your appeal was disposed of or only that IA was disposed of.
No, that because it amounts to disposal of the appeal, ma'am.
If that is then what has been, have you seen that provision, section 58?
Yes, ma'am.
So
your appeal before the appellate tribunal was under section 44.
Yes, ma'am.
So any order or decision of appellate tribunal is amenable for remedy under section 58, not under article 226 of the Constitution. That is the statute. How can you circumvent?
near.
And I just prefer this writ application because only challenging that order of the IA.
No, you see the language is very clear.
Mine.
Even if it is not a final disposal, even if any order has been passed also by the appellate tribunal,
Even interlocutory
so
orders.
interlocutory order, any order. So the language is very clear. Any person aggrieved by any decision. Decision means the final decision in the appeal,
Mine.
or any order of the appellate tribunal has to file the appeal to this court within 60 days from
Mine.
So that is how we are asking you that since appeal is maintainable, how you have filed this petition. So the option lies with you either to file an interim application to convert it to the appeal, so, or withdraw it and file the appeal with because that period is 60 days. So you are to file a delay condonation application. All these things. So whatever.
No, I may be allowed to file one application
Whatever
for
you
conversion.
But that format would be little different from the.
Your grounds will not be the same
That is
as per writ court and appellate court.
So the
This High Court will be appellate court, not the writ court.
There would be like that being aggrieved so and so. So this appeal raju format would have.
No, ground will also be changed.
Ground will also be changed.
That can be challenged on facts also. If High Court is vested with the power of appellate court, then you can challenge it on facts also. But writ court doesn't have the facts.
And if you file the appeal with the condonation of delay and take the grounds
Actually,
inadvertently.
Section 14 of the limitation.
14 will carry.
Section 14 of the limitation.
Actually, this is an appellable order. I filed this writ application only to apprise my lord the order passed by the RERA is an error for which 226 is amenable because that is almost all a nullity, my lord.
That point you can raise in the appeal. There is no problem in that. So we are disposing of that. We are giving you liberty to appeal and obviously file the limitation. This petition has been filed challenging the order dated 25/2025 passed by the Orissa Real Estate Appellate Tribunal, Bhubaneswar, in OREAT Appeal number 36 of 2023. In rejecting the application filed by the petitioner for want of deposit of the statutory amount. It appears that the said appeal was preferred, challenging the order dated 6/10/2022 passed by the adjudicating officer Orissa Bhubaneswar in AOCC number 9 of 2022. In which the one in which the opposite party number 1 was the complainant and the petitioner was the respondent. And the order was passed directing the petitioner to pay compensation of rupees 50 lakhs to the opposite party number one within 45 days, failing which the amount shall carry interest at the rate of 9.70% per annum till total realization. Section 58 of the Real Estate Regulation and Development Act 2016 prescribes appeal to this court against any decision or order of the appellate tribunal. The relevant section is quoted here in below. In view of such provision, the Land Council for the petitioner seeks permission to withdraw this writ petition to file appeal against the impugned order under Annexure 9. Accordingly, giving liberty to the petitioner to file the appeal, the writ petition is disposed of. Yes.
Item 5.
I may be allowed to get back that certified copy instead of by substituting a photocopy.
That order dated Annexure 9.
Yes, ma'am.
The certified copy of the order dated 25/2024 by
खाली annexure 9 को
Annexure 9.
detail order.
Certified copy of Annexure 9 be returned to the Land Council for the petitioner on being substituted or Xerox copy. Yes, true copy. We are just coming within 2 minutes.
Item 5 may be taken up tomorrow.
Item number 5.
He was mentioning.
Item number 5.
Mr.
May I pray, my lord? Your lordship, kindly give a glance, my lord's last order. Order dated 10th of
He
March.
was mentioning just before rising.
In this case, interim order is continuing against me, my lord.
Knight has
No, he was
requested for
mentioning for
passover. He requested for passover. Mr. Knight. All right. Next.
Item number 6.
of land and house building already taken over for the purpose of the construction of NS project. So, out of 3 repeats, 2 repeats and disposed of by the same prayer, it was segregated.
Mhm.
So, Annex 5 is the impugned in this expedition. So, on earlier expedition, it was observed by Lordships that on certain provision under the NH Act 3H, the competent authority can reassess. Three repeats and few are disposable. So, present it remain.
Eka prayer.
Take a prayer. Annex 5 also impugned order said.
without explaining. अच्छा हाँ अच्छा अच्छा देखिए हाँ
Next.
Item number 7.
Please, I'll try to order dated 20/2/2025 or Lordship directed to obtain instruction. During allotment of land and compensation by that pursuant to the earlier order of decision. The instructions are that the
This letter was sent by the consular. Raghunathpur to the kilometer. The process handled by there's some time. Is that and the level of the land action officer, collector Javishan Court. During the payment of the compensation amount, there was a beneficiary.
His prayer is twofold. One is about the allotment of Ekarsum 28 decimal of land in Moja Tarok. Number 2 is the payment of monetary compensation for the rest area, that is Ekarsum 72 decimal. To ask for the prevailing market rent. So, what instruction you have received?
The official correspondence, then there was no final.
The order was passed in the writ petition on 26/4/2018. The writ petition was of the year 2011. The order was passed in 2018, and the writ petition was disposed of that you are to give an area of rupees so and so, and also for balance you have to. So 2018 order, we are in almost 7 years have passed. So you have not challenged that order passed in the WPC. And now you are saying that one letter has been issued on 7/3/2025. So that an area so according to the judgment was instituted in the case of
May I claim that,
letter has been issued to land acquisition of collector so for payment of compensation. So that letter which was stated to have been issued to land acquisition officer collector at Jagatsinghpur, that is dated 13/11/2019 for payment of compensation, right? And what about the allotment of the land?
that had also the 5/11/24. That was issued by the.
Where is that? Where is that? 16/11/24. It has been issued to whom?
Issued by the consider to subject to negotiation. That processing the facts, so I claim a lot some more time so that.
No, this man should file an affidavit. This land acquisition officer collectorate. Why he has not paid compensation. And also about the status of that dereservation case. In terms of the order dated 22/2025, the London Council for the State has produced written instruction received from the Tahsildar Raghunathpur, which indicates that as per the order dated 26/4/2018 passed in WPC number 1772 of 2011, one de-reservation case hearing number 3 of 2019 was instituted in the office of Tahsildar Raghunathpur, and it was sent to district office Jagatsinghpur regarding approval of dereservation proposal in favor of the petitioner. It further appears that letter has been issued to the land acquisition officer collectorate Jagatsinghpur on dated 13/11/2019 for payment of compensation amount in favor of the beneficiary let Dhubai Malik, the father of the petitioner. However, no information has been received from the land acquisition officer. Let an affidavit be filed by the land acquisition officer collectorate Jagatsinghpur regarding the status of payment of compensation in favor of the beneficiary let Dhubai Malik. The Land Council for the state shall also obtain instruction about the status of dereservation case number 3 of 2019. This letter is taken on record. Matter be listed on 15th of April 2025. Copy of the affidavit be served on the Land and Council for the petitioner in the meantime. Yeah.
Item number 8.
Last University Director State of the Instruction by the order date 3rd of March 2025.
What instruction? Just read that order. Let us see.
Operating Performance. Land Council for the state shall also obtain instruction on the submission of Land Council for the petition
No,
regarding
to the whether there is any challenge to the aforesaid
Yes,
judgment
yes,
dated 6/9/2019,
yes.
and if not, why compensation amount has not been disbursed in favor of Tirochan Rana. States are also obtain instruction
On the
regarding payment of huge amount towards the interest due to delayed deposit oblique disbursement on the enhanced funds. What is your instruction?
Sending the letter will have to some more time to
You have sent the letter
4/3/2025
4/3 on the next day. To whom?
to the Principal Secretary Government and also the Additional Secretary to the Water Resource Department.
लेटर गुड़ा दिखातु आमे देखु Land Council for the state submits that as per the order dated 3/3/2025, communication has been made to the Principal Secretary to the Government Water Resources Department, Odisha, Director bracketary R&R -com ex officio, Additional Secretary to Government Water Resources Department, Odisha, Special Land Acquisition Officer and Upper Indravati Irrigation Project, Kusum Khunti in the district of Kalahandi, Zone Officer Land Acquisition bracketary 1, Upper Indravati Irrigation Project, Kusum Khunti, State of Kalahandi, as to why the compensation amount has not yet been disbursed in favor of the petitioner. But the instruction is awaited and the matter may be taken up After 2 weeks, we are granting. After 2 weeks, place this matter in the. If we you are getting much time. Put up this matter in the week commencing from 21st April 2025. Yes,
8, 9, 10, 11, and 13.
21st April 2025. ସବୁଥିରେ ଚିଠି ପଠେଇଛନ୍ତି same order in
So far, item
8, 9, 10, 11, 12
12ଟା withdraw କରି 13
12ଟା withdraw କରିବେ 13 ଆଚ୍ଛା 12ଟା withdraw
withdraw with liberty file ଆସିବେ
land Mr. Moon Land Council ଗୋଟେ memo ଦେଇଛି Land Council for the petitioner files a memo to withdraw this petition to file a better writ petition. Accordingly, memo is taken on record. This petition is disposed of during liberty. बाकी 8, 9, 10, 11 and 13 सेम ऑर्डर ରହିବ ଏବଂ ଗୋଟେ ଡେଟ୍ ରହିବ that is 21/4/2025 ठीक
Note 14.
Yes, Mr. Khatua. Out there. Pass over Quorum to next.
Item 15.
Item number 15, we please your worship for the petitioner minutes. Minutes, this is also a writ application in pursuance to the directions of the Honorable Apex Court in the MCL coal acquisition matter. Here, my lords, the case of the petitioner is for structure compensation. For a structure, if your lordship will see the survey report at Annexure 3.
You filed similar cases.
Yes, my lord.
What order was passed?
My lord, notice, your lordship has issued notice because.
No, can you give a copy of that order?
I can simply, if your lordship will give me one password, I'll take a printout.
Okay.
I have.
ये तो एक group order है चीज है मेल commission bond here also high court directly
Yes, sir.
It's item 18 also
just
same.
give one order will
Well, I'm just supplying the copy. I'll just get a printout, my lords.
the order of the issue notice is the same type order. So that is also in item number 15
15
and
18 minutes.
18. It have issue notice about, but order to madam they will. Yes, Mr. Khatua.
My lord, this is material. Under the definition pending miller, similar order will pass miller. My lord, item 13, 17, 19,
Just
20.
give one order. I think that is very important. Very major of relief for community. No opinion in the representation display. I'm sure we should. I don't know. A order କରିଦେବେ representation disposed of এটা ହେଲା ଗୋଟେ 16 then 17
16
14 ବି ଅଛି
So the password is type.
ହଁ ସେଇଟା so 14
16 17 19 20 21 22
धीरे धीरे कुहतु नोट करिवे
item number 14 लिखिले 16 लिखिले 17 लिखिले 19 लिखिले these are all representation disposed of ହେଲା then 20 also same 21 same 21 disposed of 22 also representation.
May I submit?
Item
19 to 20, 22. So the matter relating to OGL. They say I'm in possession of one government land.
Oh, then they have to apply that for proper format.
खाली representation होगा.
Representation over there form ଅଛି ଆପଣଙ୍କୁ
Form with enclosures.
Yes, sir.
କୋଉ item କୁହନ୍ତୁ
14 ଟା ବି cross.
19 to 22.
14 ବି ହବ ସେଇ OGLS.
ଯେ ଟିକେ ରୁହ
14 भी सही है फॉर्मेट रे देबे
हां OGLS आज
लेकिन item number 14 लिखले this writ petition has been filed by the petitioner Vanalata Tripathi with a prayer for settlement of the government land in his favor, in her favor. under the provisions of OGLS Act and rules. The Learned Counsel for the petitioner submits that a representation in that respect has been filed by the petitioner before Tahsildar Japni, bracket opposite party number 4, on 10/1/2024, and the same may be directed to be disposed of. The Learned Counsel for the state, on the other hand, submit that there is prescribed format in which the petitioner has to apply for settlement of the government's land under the OGLS Act and rules, and the same has not been done by the petitioner. In view of such submission, while not entertaining this writ petition, the petitioner, this writ petition, no, we are not inclined to pass any order. It is up to the petitioner to file appropriate application before the appropriate authority seeking relief as prayed for in this writ petition. The similar order to be passed in item number 14, then
17, 19.
ସବୁ ସେଇଆ
19
ସବୁ ତ ଖାଲି ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଛନ୍ତି ସବୁ ତ ସେଇଆ
କୌଣସିରେ ଫର୍ମ ଫାଇଲ କରିନାହାନ୍ତି ଆଚ୍ଛା ସବୁଗୁଡା ଡିସ୍ପୋଜ ସେଇ ଅର୍ଡର କରିବେନି ସେଇ ଯୋଉଟା ଅର୍ଡର ଦେଇଛନ୍ତି
ତହସିଲଦାର କିନ୍ତୁ ଡିଫରେଣ୍ଟ ଅଛି
ଓବିୟସଲି ଆପଣ ଆପ୍ଲିକେସନ ଟା ଯୋଉ ଫର୍ମ ଟା ବି ଅଛି ତା ବି ଦେବେ ରୁଲ 5.1 ଫର୍ମ 1 ରେ ଆପଣ ଦେବେ Yes, next.
Item number 23.
Mr. Rao,
ଆପଣ କୋଉ କେସରେ ଅଛନ୍ତି ସେ କୋଉ କେସରେ
ଆଚ୍ଛା ନାଇଁ ଯୋଉ ତିନିଟା ଡିସ୍ପୋଜ ଅଫ ହେଲା
ଦେଖନ୍ତୁ ଶୁଭଲକ୍ଷ୍ମୀ ଗୋଟେ
14, 16,
ଅରବିନ୍ଦ
17ରେ ମିଷ୍ଟର ମହାନ୍ତିଙ୍କ ନାଁ ଲେଖିଦେବେ and then
19 to 22
19, 20, 21 ଆଉ 22 ରେ ଶୁଭଲକ୍ଷ୍ମୀ ନାଁ ହେଲା ଠିକ ଅଛି ଓକେ yes Mr. Rautna.
The petition of the land house to under the OP number 1, and their land has been acquired by the MCL for purpose of code excavation.
ଗୋଟେ ଯୋଉ ଇଏ ଦେଇ ଦଉନାହାନ୍ତି ଗୋଟେ ସ୍ଲିପ୍ ଟେ କିଏ କୋଉ ମ୍ୟାଟରରେ ଦେଇଛନ୍ତି ଆଗରୁ ଦଉଛନ୍ତି ହଁ
Yes, madam. The petition of the land house to under the OP number 1, and their entire area has been acquired by the MCL for the purpose of coal excavation. You can kindly turn to have given the ROR at annex to 1 minute. The entire 5 acres and 692 decibels of land was acquired by the MCL. And after the death of Bandhuan, the petition of the legal area for Bandhuan and like that, and annexed to 12, phase 12, they are the legal areas, and they have approached the MCL for grant of compensation and employment. Until that, they have not been given any.
No, where is that?
No document has been given so that the land has been actually acquired.
That is exactly the land you acquired ହେଇଛି ଆପଣ କହୁଛନ୍ତି these are document କାହିଁ
the representation that is pending.
Representation କଣ land ଜଣା ପଡିବ ଆପଣଙ୍କର ତାଙ୍କର ଥିବ ନା ଯୋଉ ବାହାର କରନ୍ତି ଯେ ଏଇ land ଗୁଡାକ ଆମେ acquire କରୁଛୁ
section 4 notification no
section 4 notification at least କିଛି
ସେଟା earlier one ଏବେ କୋଉଥିରେ ଆସୁଛି
ଏବେ section 7
ଏଟା ନୂଆଟା ନା ପୁରୁଣା 1894
କିଛି notice वगैरह भी କିଛି ନାହିଁ to show that
4 ରେ ଥିବ ନା section 4 notification ରେ ବୋଧେ ଆସିବ
notification or କିଛି notice 11
କିଛି ଦେଇନାହାନ୍ତି ଆଧରେ petition ରେ କୋଉଠି ଦେଇଛନ୍ତି କୋଉ ପିଟିସନର ର କୋଉ ଲ୍ୟାଣ୍ଡ ତାର ଖାତା ନମ୍ବର କେତେ ଇଏ
paragraph 3 minutes
paragraph 3 section 1 କଣ ବନ୍ଧୁଆନ son of son or the recorded
ସେଟା ଟିକେ ମ୍ୟାଚ୍ କରୁନି
plot number
ସେ ତାର ଡେଥ୍ ସାର୍ଟିଫିକେଟ ସାଙ୍ଗରେ ମ୍ୟାଚ୍ କରୁନି
ଡେଥ୍ ସାର୍ଟିଫିକେଟ ବନ୍ଧୁଆନ ନାହିଁ
ନାଇଁ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଏଟା କଟା ହେଇଛି ଡେଥ୍ ସାର୍ଟିଫିକେଟ ରେ ଏଇଟା
ସେ
କଟା
ବନ୍ଧୁ
ହେଇଛି
ଏଇଟା କଟା ହେଇଛି
ହଁ ସେଟା ବନ୍ଧୁ କିନ୍ତୁ ଆପଣଙ୍କର
ଲିଗାଲ ହେୟାର ଦେଇଛି ବନ୍ଧୁଆ ନାହିଁ
ଲିଗାଲ ହେୟାର ଟା ଓଲଟା ହେଇଗଲା
Kindly see the
ତାର ମାନେ
apprentice
ପାଦଟା ଅଛି ମୁଳିଆ ନାୟକ ଠିକ ଅଛି ମାନେ
ଥିଲି ଯେ
Right.
ତାଙ୍କ ନାଁଟା ବନ୍ଧୁ ନାୟକ ନା ବନ୍ଧୁଆ ନାୟକ
ବନ୍ଧୁଆ ନାୟକ ମାନେ
କିନ୍ତୁ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଟା ଦେଖନ୍ତୁ
ଲିଗାଲ ହେୟାର ଦେଖନ୍ତୁ
ଏ ଲେଖା ହେଇଛି ଏଇଟା କଟା
ଏଇଟା ଲିଗାଲ
Who is
ହେୟାର
this
ଲେଖା
Satyabhama Naik?
Pardon?
Who is this Satyabhama Naik who submitted that
Satyabhama Naik,
representation?
the daughter of my lord, that Bandhua Naik.
No, we are asking you that what about the other petitioners? Why they have
They have not approved. Only my lord, petition number 1 to 4 and 10 my lord.
22 ଜଣ ଅଛନ୍ତି
10 ଜଣ ଅଛନ୍ତି
ନାଇଁ ନାଇଁ
ଲିଗାଲ ହେୟାର ସେମାନେ
ଲିଗାଲ
ତାଙ୍କୁ
22 ଜଣ
ତାଙ୍କୁ ଦେଇଛନ୍ତି ଆଙ୍କୁ ଦେଇନାହାନ୍ତି ସେମାନେ ପାଇଛନ୍ତି
kindly see page 15.
ଅନ୍ୟ ଡକ୍ଟର ମାନେ ପାଇଯାଇଛି
ଆଜ୍ଞା
Shall I kindly see the representation at page 15 for a minute? There's a
15?
page 15 also, that is the representation of the petition.
Ah,
That seems that is a dispute regarding the title. May I read it? ନିବେଦନର ଅଭିପ୍ରାୟ ଏକି ଯେ ଆମେ ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରୀ ଅନାଦିପୁର ମୌଜାର ବନ୍ଧୁଆ ନାୟକର ଉତ୍ତରାଧିକାରୀ ଅଟୁ ସମ୍ପ୍ରତି ଅନାଦିପୁର ମୌଜା ଭୁବନେଶ୍ୱର କୋଇଲା ଖଣିରେ ଯିବା ପାଇଁ ସର୍ଭେ କରାଯିବାର ଶୁଣାଯାଉଛି ସେଥିରେ ପ୍ଲଟ ନମ୍ବର ସଂସଦରେ କରାଯାଇଥିବା ଆମ୍ବ ଘରର ଆମ୍ବ ସମସ୍ତ ଉତ୍ତରାଧିକାର ଅଟେ ବନ୍ଧୁଆ ନାୟକଙ୍କ ସ୍ଥିତି ଅନୁସାରେ ତାଙ୍କ ଉପସ୍ଥିତିରେ ପୋଖରୀ ବିଭିନ୍ନ ଗଛ ଚାଷ ଜମି ଠାକୁରାଣୀ ପୀଢ଼ ଇତ୍ୟାଦି କରାଯାଇଥିଲା ଏବେ ଜଣାଯାଉଛି ଟିକନ ନାୟକ ଆର୍ତ୍ତତ୍ରାଣ ନାୟକ ଶଶୀ ନାୟକ କୌଶଲ୍ୟ ନାୟକ ଏ ସମସ୍ତ ସମ୍ପତ୍ତିକୁ ତାଙ୍କର ବ୍ୟକ୍ତିଗତ ସମ୍ପତ୍ତି ଭାବେ ଏମସିଏଲ କର୍ତ୍ତୃପକ୍ଷକୁ ଦର୍ଶାଇ ଏମସିଏଲ ତରଫରୁ ପ୍ରଦାନ ଅର୍ଥରାଶିକୁ ଆତ୍ମସାତ କରିବାକୁ ଚେଷ୍ଟା କରୁଛି
so how can it be? So it is to be decided first.
The apportionment as to the title.
So the apportionment, this representation would not do.
So let them file a fresh representation that will be considered at least.
Representation ହବନି ଆପଣଙ୍କର provision ହଉଛି
section 60
because they are the legal heirs, but there is no doubt they are not the legal heirs.
2013 act of apportionment ରହୁଛି
section 64 and
50
64 64 deals with
64 ର କହୁଛି reference of any person interested who has not accepted the by written application so and so on to be referred by the collector to the determination of the authority. One which amount of compensation the person to whom it is payable.
Amount has not been paid, it is still there in the
measurement एगुड़ाक सब determine करिवे authority means is the district judge.
Lara.
Oh, Lara. So obviously he has to adjudicate all these things.
So they be nahanti whether they are out.
To file, first of all, a written application is to be filed, and then prayer is to be made in that application to refer the matter to the authority, and then the appropriate the parties will be noticed, and if reference is not made by the collector within a specified time, then you can direct approach the authority requesting him to make the reference. That is the provision. So we are disposing of you while approach the appropriate authority. This writ petition has been filed by 10 petitioners with a prayer for a direction to the opposite party, number 1, that is General Manager Mahanadi Coalfields Limited, for payment of compensation as well as employment to them. The London Council for the petitioner submitted that some representations have been made to the concerned authority in that respect. However, no fruitful result has come out. The London Council for the state, on the other hand, referred to one of the representation dated 9/1/2024, from which it appears that there is dispute between the parties relating to apportionment, and therefore the London Council for the petitioner seeks permission to withdraw the petition to approach the appropriate authority in accordance with law, seeking the relief as sought for in this writ petition. Accordingly, the writ petition is disposed of. Yes,
Direct the collector, they will approach.
you approach it. There is no permission is necessary. Yes.
Item number 24.
Item 24, I request some further time to comply with your. I request some further time to comply with your. The taking
What time you take?
6 weeks. Your Worship. Can I pray for 6 weeks?
Okay. The Land and Council for the state seeks some more time for obtaining instruction regarding compliance of the order dated 3/10/2024 passed in WPC number 24517 of 2024. We are keeping it to the May 1st week, but comply the order. Otherwise, first content petition dispose of second एकाथरे से relief नहीं दिए.
Yes, sir.
देखो मार्च रो फर्स्ट वीक sorry May रो फर्स्ट वीक रो है ना. Next.
Item number 25.
So 25, 26, 27, all
Same.
up to 27 years.
Aguru order pass
It is the second time.
second time. Same order for the 5/5/20. Asur, Puta. Nothing.
Sir, item number 5.
5 minutes I am appealing for the opposite party.
It's your time mode to tally from Pratham Ranu.
Tomorrow will put.
Kali Grab
Again.
this matter tomorrow. Yeah.
Item number 28.
There is a delay of about 15 days in preparing the outfit. And delay is due to the official communication section. The last occasion, since my friend was not there, it was not. Yes, sir. 15 दिन कौन पूछे थी? Delay कौन? No, no. आज ही खाली वो इट आस्ती order पाइन केवल delay condonation है ना? तो MC number 552. You are the sole. Yes. Yes. The 552 of 2017. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 15 days in filing the writ appeal. The Land and Council, appearing for the respondent, submits that he has no objection if the delay is condoned. Considering the submission made by the Land Council for the respective parties, the averments taken in the application for condonation of delay, we are inclined to condone the delay in filing the writ appeal. Accordingly, delay is condoned. This case is disposed of. What is this second MC? How would I? Now it will be listed for admission.
17/5 no ମାନେ stay ହେଇନି ସେଇଟା ବି message ର କହିଲୁ contempt 17/5/19 ର order ଟା issue is covered by lordship's order ଟିକେ time ଯଦି my lord
75 ର order ଟା ଦେଖୁ
7 ବର୍ଷ ହେଲା ସେ same series of judgment ଏଇ letter pass ହେଲାଣି
ଦେଖେବେ whether it has to come. Obviously, writ appeal is now to come under the heading of admission. Because the delay is condoned, so it will come under the heading of admission next week. All right. Put of that matter.
Kindly see order dated 17/5/19.
कौन है जी 75?
ସେଇଥିରେ IRA जो IIT ପଚାରୁଥିଲେ IRA there is a interview stage, so that may be
That is all right.
till next date ଥିଲା ତ may be continue.
List this matter next week. Next week we commencing program. আমার 2 তারিখও করবেন, তাহলে 7 করবেন। 7th of April 2025 for admission, interim order dated 17/5/2019, passed in this case number 553 of 2017, shall continue till next date.
Yes.
Item number 29.
Lordship, I pray for an adjournment. My senior counsel, Mr. P.K. Mahanti is on legs in and pray for an
There are 1,000 some odd days delay. I am appearing for the respondent and legal acts of respondents.
Delay condonation. You have filed your objection.
No, I have not received the notice because lower court the counsel was appearing in this before the notice.
Please let us see in the
I was given a copy in respect of the writ appeal.
no,
Yesterday I entered appearance.
writ appeal can be, I mean, delay achieve. 1021 दिन देखेगी. So that is to be considered first. So why have you not served the copy of the your IA for condonation of delay? Serve a copy. Interim application. Lekhantu IA number 2467 of 2021. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 1061 days in filing the writ appeal. Land counsel for the, you are appearing for all the respondents.
The LRs have responded number 1.
Land counsel appearing for the LRs of respondent number 1, Dhiren Kumar Pradhan, submits that he has not been served with a copy of the interim application. Stop. What is your good name?
Your Lordship, my name is Prasenjit Pani.
Prasenjit Panigrahi.
Only Pani.
Prasenjit Pani. Prasenjit Pani, Land Counsel, appearing for the Mr. Pradeep Kumar Mahanti, Senior Advocate, submits that copy of the interim application will be served on the Land Council for the respondent by Tuesday for those. On Monday, by 2nd of April 2025. So we are giving you one more week time and you can file your objection to the interim application.
And also counsel affidavit has been filed by my predecessor.
Matter be listed in the week commencing from 21st of April 2025. Objection, if any, to the interim application for condonation of delay is filed in the meantime. Yes.
Item number 30.
Item number
30 withdrawal.
30 the withdrawal enhanced
Memo. Santosh memo. Second operation
memo has been filed by the petitioner for withdrawal of the writ petition. The writ petition is disposed of as withdrawn. Yeah.
Item number 31.
Union of India.
Union of India तरफ से अच्छा legal comprehension. Okay. Yes, next.
Item 31.
Actually, some of the things are certain Naik is assigned.
Naik is to argue the matter.
Is in personal difficulty held up in other courses.
ଏଇଟା ବି ସେମିତି ଅଛି condonation of delay ପାଇଁ ଅଛି
Pursuant to lordship order, I have filed the objection.
କେତେ ଦିନ delay
320 days, my lord, 1 year.
ତ କେବେ ଚାହୁଁଛନ୍ତି
Next week.
so the it is stated by the land council for the state that Mr. Naik is to Naik mane kiye assailant. Yes, Mr. Naik.
There is 320 days delay.
He has filed objection. What you have stated in your objection?
We have stated, if lordship, if delay is bona fide and reasonable, it is up to your lordship matter. I have read a judgment of division bench of this honorable court where the delay was not condoned. And this is not
Sufficient cause कौन?
My lord, sufficient cause is, my lord, during COVID, there was a half strength, the office was functioning, AG office was functioning. One of the reasons.
That cannot be. For the department, it cannot be.
That is up to your lordship, my lord. I am.
Unless there is a question of law, like in a writ appeal, I sitting with Honorable Chief Justice as Lordship was Secretary Submission, condone the delay, considering that unless it is condoned, a conflicting opinion could ensue. Because Joseph Barrick case was there.
Lord, in this case, what happened on merit, my lords, the case was posted to obtain instruction. On the last day,
just let us see that what order you are challenging in this writ appeal.
Order annexure 1.
Just a minute. Writ appeal re apna challenge କରୁଛନ୍ତି annexure 1.
My lord.
That is the order dated 7/12/2021.
My lord. First order, my lord, directed to obtain instruction what steps taken against the person who illegally engaged the petitioner. On the second date, no instruction was therefore this honorable court.
Mamata Manjari Mahanti case is fairly covered, which Honorable Single Judge has said. So
that was not examined in this case. Whether this case is covered by Mamata Manjari case or not, that was not examined.
So you delayed the matter.
In paragraph number 5 of that order dated 7/12/2021, we find that it has been mentioned that despite opportunity being given, the Land and Additional Standing Council has not obtained instruction. So when the case was first posted to
that is the
WPC Bar College
WPC
first order ta hi kebe
26/11/2021
26/11 रे order ta hela ebong
7/12
a query was made by this court as to whether the authority has taken any steps against such horticulturist who was given the appointment illegally, inuring benefit to the petitioner, and the State Council submit that since it's an old case of 2002, he has no instruction and he may be granted some time to get up-to-date instruction. For this matter, one is up in the meantime instruction between. What was the prayer in the writ petition? It was transferred from that State Administrative Tribunal, and accordingly that WPOAC number was registered, right? So what was your prayer in the before the tribunal? We graciously pleased to pass the order dated 17/12/2002 in annexure 5 and allow the applicant to continue in his post as laboratory attendant.
Para 4 is very clear. But the opposite parties, even after the petitioner had completed 6 years of service as a regular employee without following the principles of natural justice, meaning that without giving opportunity of hearing and without following the prescribed procedure, have terminated the petitioner. Similarly situated, another person was given.
That is
That
that.
is
He is
Mamta
continuing.
No. Sangram Das.
He is continuing.
It is further contended that in similar manner, one Sangram Das, who was appointed as a laboratory attendant, was also terminated from service without any notice on the allegation that his appointment was irregular. But subsequently, he approached the Odisha Administrative Tribunal in OA number so and pursuant to the order dated such and such, the tribunal he was allowed to continue as a regular employee. It is further contended that the case of petitioner Mamata Mangal. So
That is there, my lord.
Ah.
My lord, my sole contention is whether
how
the
can you
case of the
discriminate?
Sudhanshu Mohan Mahanti is similar
So,
with the Mamta.
First of all, you cannot discriminate, number one.
My lord.
And you have
Without
not
so-called-
placed on record
Here
whether
also,
the horticulturist was proceeded against.
here also 6 years service he has completed.
My lord.
The person who has given the irregular appointment, he is not taken to task. So such a
What
such
about
original-
continuation?
I am not continuing.
Then
what is your age?
50. 50.
Hmm?
50, my lord.
In 2002, you were 29 years. এইটা তো নোট করেছে ডব্লিউ নম্বর 688 of 2022 ଆମେ କରିଥିଲୁ 15/5/2024 ଜଜମେଣ୍ଟ ପାଟିନାଟା ଷ୍ଟେଟ୍ ଅଫ ଓଡ଼ିଶା versus ମମତା ମଞ୍ଜରୀ ମହନ୍ତ এইটা ঠিক ମମତା ମଞ୍ଜରୀ କେସ୍ এইটা সেই কেসটা মমতা মঞ্জରୀ যেটা রেফার ହେଇଛି
relying the Mamata Mandiri allowed the writ petition. And it was a writ appeal.
ରିଟ୍ ଅପିଲରେ ମମତା ମଞ୍ଜରୀ ବାସ୍ କନଫର୍ମ ମାନେ ଏଇଟା ହେଇଥିଲା ତେଣୁ ସେଇ ବେସିସରେ କଣ ନା ଫେର ଆଫିଡେଭିଟ କଣ ଫାଇଲ
On
କରିଛନ୍ତି
record also I have filed.
ଆସିଯାଇଛି affidavit dated আচ্ছা
Annexure 5 ରେ ଅଛି।
affidavit আসেনি কেবে ফাইল করি
30/24 counter affidavit affidavit on behalf of the respondent my lord 38 my lord this affidavit it was filed and received with the email.
Writ appeal affidavit on behalf of
আচ্ছা
sole respondent
Madam.
যেটা বলছিলেন তো
This affidavit
আসছি
এটা
কাউন্টার সার্ভিস
flag
30th August
D রে আছে
ফ্ল্যাগ
counter affidavit
flag D টা writ appeal writ appeal
madam
writ appeal affidavit on behalf of sole
sole
respondent
respondent
সেগুলা তো
madam
তিরিশ 2024 ফাইল
ସାର୍ 2024
ସେଗୁଡା
ସେଥିରେ କଣ ସାର୍ଟିଫିକେଟ ଅଫ ମେରିଟ ଗୁଡା କଣ ଦେଇଛି
ମାନେ chapter କୁ ଆୟ ଫାଇଲ
ଏଇ ମିଳିଲ
my lord R5
15
annexure R5
ঠিক আছে
ନା ଠିକ ଅଛି
ঠিক আছে ঠিক ফ্ল্যাগ ডি affidavit
ତା ଦେହରେ R5 ଟା ଅଛି ସେ ଯୋଉ ମମତା ମଞ୍ଜରୀର ଜଜମେଣ୍ଟ ପେଜ 16
ସେଟା ମୁଁ କରିଛି
respective matter tomorrow ପଳେଇ ଆସିବ
Don't mention my lord. Father-in-law of the appellant my lord died 40 days rituals. Interim bill.
When death took place?
On 28 start of
28.
yes my lord. 28 March.
28
March रो start of. 28 रो start of.
28 start of ମାନେ अरे डेथ के बेला
डेथ my lord 17/2 रे
17/2
yes
give the memo found. Yes.
Supplemental list, item number 1.
Not legal. Case admission, my lord. Arrive for life, my lord, to offense under 302. Fine, my lord, 10,000.
Part admit for the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial court record. In the meantime, learned counsel for the appellant shall supply the deposition copies of the witnesses examined in the trial court to the learned counsel for the state.
Position copy जो ना कोई
नहीं नहीं पेन ड्राइव रे आसिला परे नहीं ए ऑर्डरटा रहिला ट्रायल कोर्ट रेकॉर्ड आसीगला परे पेन ड्राइव रे नहीं जिबे तापरे तम सप्लाई करदे और फिर पेन ड्राइव नहीं
Item 2.
The procedure and answer the appellant is rated about 72.
See, we have already appointed her and directed the registry to.
Her name has been
Name has been reflected. So, can you just talk to her today that we can bring it tomorrow? List this matter tomorrow. Non appears for them, but list this matter. Yeah.
Item 3.
May I take the list? I for bail LLC, the judgment dated 4/10/2021.
There is a prisoner's petition.
If that has been considered, T.K. Dwivedi, along with me.
Order is the full time should
Order is.
T.K. Dwivedi. Prisoner's petition of order is.
there are several prisoner petitions.
केबे order is? No, there is no order.
Yes, sir. Order that. I was verifying in the
13/2/2023 रे लिखा है तापस कुमार द्विवेदी learned counsel appearing in the court submits that in the meantime the appellant has sent a letter expressing his desire to engage him as the counsel.
Yes, sir.
ତେଣୁ ତାପରେ ପିଟିସନ ଟା ପ୍ରିଜନର୍ସ ପିଟିସନ ଆସିଲା ଅନ୍ ରେକର୍ଡ କିନ୍ତୁ ପ୍ରିଜନର୍ସ ପିଟିସନ ଟା ଆକ୍ସେପ୍ଟ ହେଇନି ବା ତା ଦ୍ୱାରା ପ୍ରେୟାର ବି ଇଏ କରାଇନି ସେଇଥିପାଇଁ କୁହାହଉଛି ଆପଣଙ୍କୁ. So to engage Mr. B. Tripathi, Vishwajit Tripathi, right? What is your good name?
My name is S.K. along with the T.K. Dwivedi. After that order, we have
there are two. गोटे पिटिशन आसला 11/10 रे आ गोटे पिटिशन आइछि 9/10/2024 रे टीके द्विवेदी को instead of विश्वजीत त्रिपाठी, अच्छा कितना पेज में फिर समझिए
Other petition were regarding bail and updation in the status.
17 to 2023 lordship, along with TK Dwivedi, we appear lordship.
wait. Charity prisoners petition से दी चलें हमसे medical problems तीन डालना और देखा जाओ नहीं अपील अच्छा तो latest prisoners petition so far as engagement of advocate is concerned that is dated এটা হচ্ছে কেবল flag number 2 এটা হচ্ছে 9/10/2024 स्वतंत्र कारागार रही अभिनव अभिप्राय कि नुआ करी देइथिबा वकील विश्वजीत त्रिपाठी मोर केस को तुरंत जानी तेणु पूर्व देइथिबा वकील जहाँकर नाम तापस कुमार द्विवेदी को मोर केस लड़िया अनुमति चाहूँ so you are for me
Along with TK Dwivedi lordship.
what is your
Bokalatrama filed on 17 to 2023.
देखिए okay
पावर भी আসছে আমার
13/2/2023 है
17/2/23 पक्की होगा बकलात्रामा along with
petition ଅଛି flag 1 ରେ
letter of ପରେ ଆସିକି letter of ଦେଖି ନଥିଲେ ସେତେବେଳେ ଦେଖନ୍ତୁ period the prisoner's petition dated 9/10/2024 8/10/2024 at flag 2 wherein prayer has been made to engage Mr. Tapas Kumar Dwivedi as his advocate. What is the wakalatnama of Dwivedi?
along with my lordship 17 to 2023 Bokalatrama is filed TK Dwivedi along my
देखो उधर वकालतनामा कौन बोले हाँ
এটা কপি
17 wakalatnama has already been filed by Mr. T.K. Dwivedi along with Mr. S.K. Baral and his other associates. The wakalatnama is accepted. The name of Mr. Vishwajit Tripathi and his associates shall not be reflected in the cause list henceforth. Yes, what is your prayer in this IA?
IA for bail lordship. I have been convicted on
No, there are two IA. One is for bail, the other is for interim bail.
Interim bail already disposed of lordship.
Dispose of him or ରହିଛି ବୋଲି ଆସୁଛି ବି
7/7/22 ରେ
7/7/22
ରେ interim prayer was refused.
This is an IA number 2422 of 23. So how a 23 matter can be taken up in 22? IA number টা ভার করো 2422 or 23. This is an application for interim bail. On the ground that your mother is suffering from cardiac problem. So you don't want to press this.
No.
All right. IA number 2422 of 2023. There is an application for interim bail. London Council for the appellant does not want to place the interim application. Accordingly, IA is disposed of as not placed. ହେଲା ତାପରେ ଆଉ ଗୋଟେ ରହିଲା IA number 1221 of 2021.
Yes. For bail.
So whether your bail application was ever rejected on mail?
No.
Let us see that. Oh shit.
Bail application was rejected on 7/7/2020.
Yes.
Interim bail application was rejected on 7/7/22.
हाँ नहीं मेरिट रे
Like on the
Merit dispose in.
मेरिट रे इटा डिस्पोज ऑफ क्लेम
No.
but let us take the necessary permission because since one of the judge is still available here, those who have rejected the bail interim bail application. So let's do IA number 1221 of 2021 is an application for bail. It appears that the appellant's earlier prayer for interim bail in IA number 1018 of 2022 has been rejected as per order dated 7/7/2022. Is this matter before the appropriate bench with the approval of the Honorable Chief Justice for consideration of the bail application?
Item 4.
Deposition copy so that I can.
But
I don't have the deposition copy.
you have not supplied.
ମାନେ ମୁଁ ଆଜ୍ଞା ସବୁ ଯାକ ପେନଡ୍ରାଇଭରେ ଆଜ୍ଞା ସବୁ ନେଇଥିଲି ମୋ ପାଖରେ ଡିପୋଜିସନ କପି କିଛି ନାହିଁ ମୁଁ ପେନଡ୍ରାଇଭରେ
ଠିକ ଅଛି
ମୁଁ ନେଇଥିଲି
so
ମୋ ପାଖରେ ଆଉ ଆସିନି
you just take the trial court record has come, so the learned counsel for the state submits that she is not having the deposition copies of the witnesses, and she may be permitted to take the same from the trial court records in her pen drive, soft copy of the deposition.
already ଆଜ୍ଞା ନେଇଯାଇଛି ସେଟା
ବୁଝିପାରୁନାହାନ୍ତି ତାଙ୍କ ପାଖରେ ନାହିଁ
ଆଜ୍ଞା
put of this matter next week. You give your pen drive, otherwise this matter is listed, it can be given to you immediately, right? Yeah.
Item 5.
Here your lordship had called for the criminal antecedents and custody certificate. Criminal antecedent has come in the last week. It awaits custody certificate.
Pass on. The so far as criminal antecedent is concerned, there is no criminal.
No criminal antecedent.
One criminal antecedent.
No criminal antecedent.
ଆମେ ଲେଖିଲୁ
ଗଲା ଥର ଲେଖା ହେଇଛି ପରା
28/2/2025 ରେ ସେଇ ଗୋଟିଏ କେସ୍ ଯୋଉଟା ଏଇ ଯୋଉ କେସ୍ ରୁ ଅପିଲ ଆରାଇଜ କରୁଛି ସେଇ ଗୋଟିଏ ଆପଣ please see that if you have doubt verify the case number also. ସେଇଆ ତ ଆପଣ କହୁଛନ୍ତି ଗୋଟେ କେସ୍ ଅଛି The total sentence is 6 years and 9 days. Yes. Your earlier bail application was never rejected, Mr.
No,
Pandit.
your lordship had just granted interim.
On what date?
Granted, your lordship may see order dated.
Time found to.
They have filed surrender certificate.
ये serial number 115 फाइल କରିଛନ୍ତି। 115 ତ ନାହିଁ କିଛି। Forward हो गए problem। What is the case?
The case of murder, my lords. The fire was lodged a day after, and the eyewitnesses' evidence is discrepant.
How many persons died?
One person.
Who are the eyewitnesses? What is the name of the deceased?
My lords. Name of the deceased is
Samishi Rao Miniaka. Date of occurrence is 9/2/2019.
Yes.
So, who are the eyewitnesses?
My lords, the eyewitnesses who were examined, number one is PW1, the informant.
PW1,
Informant.
PW5 and
PW4.
PW4 and PW5.
5.
तीनटा तो?
5.
अच्छा, गोटे
How do you know resign कर दी?
14 में. Out of PW14. And who is the doctor who conducted PM?
Doctor is PW10. 13.
PW13. अच्छा, एक नंबर साठी पड़े असं. PW1 is the informant.
Yes, ma'am.
So 9 months back, myself, once with the privileges deceased.
The incident is alleged to have happened in the afternoon. FIR was lodged in the evening.
Mango tree. At about 1 p.m., accused Raju Miniaka. Who is Raju? This petitioner.
Petitioner
Arrived at this spot.
got from our backside and gave a tangia blow on the backside of the neck of deceased victim Samisi Rao Miniaka. By the cut blow of the tangia, victim Samisi died at the spot. I rushed to the village and called the villagers. Raju was searched and apprehended along with the tangia. He was tied with a rope in the mango tree under which we were sitting. Matter was intimated to police by telephone information by a person of nearby village Guruthi, whose name is Somnath. He has not been examined.
Same evidence has been given by all the eyewitnesses.
No. Evidence of PW4, your lordship will see is page 54 of the paper book. At a distance of 20 cubits below a mango tree, deceased victim so-and-so and accused Raju were sitting.
Same.
I saw the victim so-and-so was attacked by a tangia by the accused Raju, which resulted in the death. The backside kotha कहली. Cross-examination Paragraph 3, the last line. It is not a fact that I have not stated before police that deceased victim Samisi Rao Miniaka and Raju were sitting at this spot.
IPC 14.
14 है I was sitting below a jackfruit tree near the Ambatota. Samisi was present in a place below the mango tree From a distance of 20 to 30 feet at about 1 p.m., I saw the accused, Raju, standing on the dock, gave a tangia blow on the neck of the victim. Cross-examination, he says that police has never examined me and he has denied being not present. The doctor has found a lacerated wound. Page 69 is the medical evidence. DW 13.
You stated that this is possible by Tangia.
He has stated, me lords.
Paragraph number 7.
He says, I have received a query. I opined that the weapon of offense produced for me, that is the tangia, can possibly cause the injury and may cause the death. Now, what he has stated, your lordship may see in cross-examination what he states at paragraph 7, page 71. Fourth line. It is a fact that I have not conducted any test on the tangia nor noticed any specific mark on the tangia. Police have not asked me about the weight of the tangia or my opinion. I have only given my opinion, restricting myself to the queries raised by the police. The tangia is a sharp-cutting weapon, my lord. How is a lacerated injury possible?
He has put the question, he has made the query. You should have put in that way, that at least to show that the sharp side has not been used.
That he has not stated.
He has stated that the tangia can cause that blow. So some question should have been put in that light. It has not been.
Not then Raigada.
No, that we know that it's a jail criminal. Is it a jail criminal appeal or regular appeal?
A jail criminal.
So you say, Land Counsel, Mr. Pradhan,
6 years he is in custody.
when somebody is assaulting with a sharp cutting weapon like tangia, if you would have used the sharp side, ordinarily either incised wound or cut wound was expected. But the doctor PW 13 has noticed the lacerated wound. Lacerated wound, obviously that shows that the blunt side has been used. टांगियार से जो पट्टा यूज है sharp side use. So there are number of decisions that if a person is having a weapon and not using the sharp side, and so it is very difficult to show that he intended to commit the murder. So they have altered the conviction to lesser offense like 3, 4, part 2, etc. So that is his submission. But ultimately it is to be adjudicated at the final stage of the is in custody for
6 years.
the jail criminal appeal.
6 years.
No. Are the land counsel for the petitioner, land counsel for the state. The land counsel for the state has produced the custody certificate of the petitioner, which says that the petitioner is in self custody for 6 years. Custody certificate is taken on record. The land counsel for the petitioner submits that though 4 eyewitnesses, that is PW1, PW4, PW5, and PW14, all have stated that the petitioner assaulted the deceased by means of a tangia, but the doctor who conducted post-mortem examination has noticed a lacerated wound on the right side back of the neck, and though he has opined that Tangia can cause such injury, but the prima facie it appears that no sharp side of the weapon has been used. Since the petitioner is having no criminal antecedent, as per the instruction received by the land council for the state, and the appeal is not likely to be taken up for hearing in the near future, the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail. There's the evidence of the eyewitnesses, also the evidence of the doctor. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced, post-mortem report finding, period of detention of the petitioner in judicial custody, absence of any criminal antecedent, absence of any chance of early hearing of the appeal in the near future. We are inclined to release the petitioner on bail subject to condition. It shall not indulge in any criminal activities allowed.
Arjun.
Item 6.
Yes, Mr. Niranjan.
Sorry. Fine status.
Fine, sir. It is fully paid. Otherwise, you should have come.
In this case,
What is this prayer for interim bail?
the parents are so I have
कौन है जी?
parents करो देह भल नहीं बोले कि सेके बापा मां को previously
What time is it? बापा मां को फिजिकली हला ପରେ ଆଣିବେ instruction ନା ବାପା ମାं ଦେହ ଖରାପ medical document ଦେଇଛନ୍ତି instruction ପାଇଁ ନେଇଲେ
ତିନି ଚାରିଟା ଡେଟ୍ ଦେଇସାରିଲେଣି କପି ଦେଇନଥିଲେ କହିଲେ ତିନିଟା କପି ବି ଦେଇସାରିଲେଣି ଏକ୍ସଟ୍ରା ଲାଷ୍ଟ ଟାଇମ୍ ବି କହିଲେ ଟାଇମରେ ତା ପୂର୍ବ ଟାଇମ୍ ବି ଦେଇଥିଲା ବିହେଭିୟର ଆଣ୍ଡ କଣ୍ଡକ୍ଟ ରିପୋର୍ଟଟା ଅନେକ ରିପୋର୍ଟ ମାଗିଥିଲେ ବିହେଭିୟର କଣ ଯୋଉ ପିରିୟଡରେ ଯାଇଥିଲେ ସେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ଯାଇଥିଲେ ପ୍ରିଭିୟସଲି ଯାଇଥିଲେ 26 ନା 2023 ରେ ଯାଇଥିଲେ ଏବଂ ଆଉ ଗୋଟେ 9/7/24
there are some problems because the documents of aims have been filed so ଆଣନ୍ତୁ report କେତେ ଗଡେଇବେ ଆପଣ can you bring it next week? Year number 1. Land counsel for the state 6 months further time, elected revision and distribution for India. 6 months further time to obtain inspection. ଆପଣ ପ୍ରଥମ ଟେକଅପ୍ ହେଲା ତାପରେ ପୁଣି ନେଲା 11/3 ଆଜି ହଉଛି ଆପଣଙ୍କର ତୃତୀୟ ଦିନ ନାଇଁ ତୃତୀୟ ଦିନ ବି ଯାଇଛି ତିନିଟା ଗଲାଣି ଆଜି ହଉଛି ଚତୁର୍ଥ the land council for the appellant opposed the prayer for adjournment on the ground that case the interim bail application consideration has already suffered 3 adjournments. It is this matter on 3rd of April 2025. Yes.
Item 7.
Lordship. Lordship's current permission, I will to date chart I have filed list of dated events. Here mirrored the sole appellant has been convicted of
you have received the deposition copies?
Yes, please. By judgment dated 15th of September 2023, passed by the learned First Additional Session Judge Barampur, Ganjam, where the learned trial court has convicted the appellant for commission of offence 302, 457, 201, 380, 364A, above 34 IPC and sentencing to undergo imprisonment for life and to pay a fine of rupees 10,000. There are 2 accused persons who are facing the trial. The other accused persons who are being acquitted. There's a lady. The fact is that the child was kidnapped.
Judgment indicates the
One person.
accused.
One person.
One
facing trial.
That is a separate split of trial, the judgment trial.
No, why you said that two persons were facing trial? Only the
Yes,
judgment
in this
indicates that the Syria alias
Yes.
Sridhara Mahapatra is the sole accused.
Sole accused.
No.
Sir. In ST case number, same occurrence, ST case number 60/2016. The other lady accused, along with the both accused persons committed the
See,
crime.
1 year son of the informant, he was kidnapped and then ransom was demanded.
Yes.
And over telephone, and the ransom was 10 lakh. So the ransom amount could not be saved. And then that murder was committed. And the dead body
was recovered. Yes,
on the basis of pure confessional statements. Where it was recovered?
It was recovered near a Amarilata MKCG hospital in a suitcase. The dead body was recovered in a decomposed condition.
So why bail will be granted in such a case?
That
Yes,
apart, my lord, the
Let me submit. Just, my lord, the case is based on circumstances evidence. There are circumstances that my lord 27 of Indian Evidence Act, as well also confessional statement of the appellant. Your confession statement, I will lordship to take you subject to your kind permission, kindly see the judgment, into judgment, page 39. Internal page 9 and Miller the brief running page 39.
So it's all right. At your instance, that suitcase was recovered and it was a locked suitcase, and in that suitcase, that putrefied body of the deceased, who was aged about 1 year, was there.
I may permitted to place subject to kind permission 39 running page. The learning sub-parameter, you lordship kindly see. The Learned Defense Counsel has been successful in demolishing the prosecution case as to the extent that the accused Sridhara was not identified by the informant at the spot while snatching the ransom bag. The material witnesses, Pandava Patra, the brother of the informant, is neither charge sheeted nor examined in this case to prove the nexus of telephonic conversation related to the demand of the ransom by the present accused. The Lordship may kindly then I'll take you lordship subject to kind. So there are two witnesses. The page 44, your lordship may kindly see. PW10 6.y. PW10 Babaji Patra, being the seizure witness, has admitted his signature by Exhibit 4. He has not supported the seizure, elicited his ignorance and affirmed the denial of the seizure made in his presence in response to the contradiction of his 161 statement by the prosecution being hostile. He has affirmed his denial.
Straightway come to running page 88, internal page 58, paragraph number 16.
Around 58, space.
Internal page 58, running page 88, paragraph number 16.
Well, good. From the aforesaid ratio settled by the Apex Court and the provisions of Section 106 Indian Evidence Act, it is clear that the onus is on the accused Sridhara to explain his innocence and to unveil how he led them to the discovery of the incriminating materials and the body of the deceased. The defense has not given any explanation to the accusation made by the prosecution. Instead, has taken the bald plea of ignorance of the denial simpliciter. The evidence and record establish the circumstances to indicate that the accused had concealed the body of the deceased amidst the Almari Latta bushes of the MKCG medical campus after murder of skin of the offense thereafter absconded. The accused was apprehended subsequent to the police trap while he had been to the spot to collect the ransom. The accused had the special knowledge about the whereabouts of the deceased as he had identified the place of concealment of the body of the deceased. He is supposed to know and explain about the whereabouts and the disappearance of the deceased. The defense has failed to discharge the onus by giving any possible account about the disappearance of any of the explanation denying the evidence. The accused had failed to offer any cogent explanation which is untrue. As such, it can be treated as an additional link.
What you said is how anyone you could know that there is a dead body inside that suitcase which was locked, and at your instance it was recovered from that Amari Lata tree in MKCG campus.
But that is
apart from that, this ransom amount was demanded, and number of witnesses have stated also in that regard.
I'll take you to Lordship 2 statements deposition. PW 23 is the the informant. I'll read thereafter. The seizure and the person who
No,
present
you
the
can argue
police.
the matter. It's not a bail. You are on bail during that.
10 years, 10 years, 8 months. And another person is acquitted.
That is a lady though. You
No,
are the
lady
main
also.
person.
Lady and nothing has been recovered.
And in this case, the chain
It is
is
a 24 appeal. So you are in custody for 10 years.
10 years, 8 months.
Have you brought the custody certificate?
Yes, my lord.
What is the year of custody?
10 years, 18 days.
And what about the criminal antecedent?
One criminal incident.
This one or another case?
Another case.
What is that offense?
379.
Stay for some time more.
379 तो से extortion ही होगा.
And so this is an application for stay of realization of fine. This is allowed. So for IN number once is concerned, the matter will be listed after summer vacation for them. Yes, for consideration of the bail.
Obliged.
Item 8.
And I'm pressing the bail application. It's IN number 490. 2020.
Have you rejected it?
No, ma'am. The first application.
What is the offense here?
Offense on section 302, my lord, operative portion of the judgment, your lordship, kindly have a glance. Case 96, paragraph 46, conclusion. In view of the foregoing discussion, I hold that the prosecution has successfully proved its case beyond all reasonable doubt regarding commission of offense, culpable homicide, amount to murder, punishable under section 302 IPC against the accused Madhav Padi, as such as found the accused guilty for commission of the offense of culpable homicide amounting to murder, punishable under section 302 IPC. He is convicted for the said offense as per section 325.
What is the name of the deceased?
Mukesh Ponda.
Mukesh Ponda. Huh?
Rajesh Ponda.
Rajesh Ponda.
Rajesh Ponda. My lord, what happened, my lord?
Just a minute. Date of occurrence is?
30/3/2022.
So eyewitnesses are there.
Eyewitness, my lord, the case is based on eyewitness PW1, PW2, 3, 6, and 11.
PW1, 2,
3, 6, and
3,
11.
6, and 11.
My
They are the 5. And who is the doctor who conducted?
Dr.
PM.
16.
16.
Yes, ma'am.
So what the eyewitnesses have stated, you come to one eyewitness, let us see. One has not supported the prosecution.
One has not supported.
So come to 2. What you stated?
I know the informant Balram Panda. I know this is Rajesh Panda, who was working as the supervisor under me. I know the accused Madhav Padi standing in the dock. The incident occurred in the intervening night of 29/33, 2022 at about 12:30 to 12:45 a.m. near the town PS Balesur. Construction of drain was going on at such place. I stood at such work site and supervising the work. The deceased Rajesh Panda sat on the bench near to the same. At that time, the accused Madhav Padi arrived there and assaulted on the head of the Rajesh Panda by means of one iron dhurmus. Then Madhav fled away from the spot, leaving that dhurmus. I found profuse bleeding from the head of the Rajesh. He fell on the ground. I, along with Shiva Hansda, a labor working there, shifted Rajesh to DHS Balesur. DHS Balesur, doctor declared Rajesh as dead. 2 or 3 days prior to such incident, operating to construction of drain in front of their house, severe commotion occurred between Madhav and
If the
Rajesh.
case of 22 means you must have remained in custody only for 2 years.
My lord, but the case is coming under the purview of section 304 part 2 of the IPC.
How do you say? Where is the quarrel? Where is the provocation, grave and sudden provocation?
My lord, all of a sudden, all the witnesses.
All of a sudden, that doesn't mean that it will come. There is to
There
be
was no intention. That was no
how do you say
premeditation.
ଗୋଟେ ଧୂର୍ମସରେ ଲୁହା ଧୂର୍ମସରେ ଜଣଙ୍କର ମୁଣ୍ଡକୁ ମାରୁଛନ୍ତି ଆଉ ଆପଣଙ୍କର ଇଣ୍ଟେନସନ ଆଉ କଣ ହେଇପାରେ
Dhurmus was lying there, my lord.
Lying there okay,
there was an altercation between them. Heat of the moment, the petitioner, the appellant took the dhurmus and attacked.
And see the nature of injury, the impact of the blow, what it has caused. So many lacerated wounds and abrasions are there, and the scalp that was found, that hematoma is there, fissure fracture is there, and
only one blow, my lord. But the prosecution has not
impact कौन ହେଇଛି ଆପଣ ସେଇଥିପାଇଁ କହୁଛି ଯେ ମେଡିକାଲ ରିପୋର୍ଟ ଦେଖଉଛି ଯେ ବ୍ଲୋର ଇମ୍ପାକ୍ଟଟା କେତେ ଦୂର ଥିଲା ଯୋଉଟା କି ଏସବୁ କରି ହ୍ୟାମରେଜ କରି ଫ୍ରାକ୍ଚର କରି ଟେମ୍ପୋରାଲ ରିଜିୟନର ତାକୁ it is not necessary that you should cause multiple blows so that it will be a case under section 302. Even if a single blow is caused, the impact of blow is of this nature, it can also be a case under section 302. And
knowing that the
part of the body selected, the weapon used, the force of assault, impact of blow, all these things, and absence of totally any material that it will come within any of the exceptions as provided under section 300 of the Indian Penal Code. So how do you bring the case under either 300 part 1 or part 2?
I'm citing one judgment.
Keep that judgment for the final hearing of the appeal. This IA number 1 so is for bail. Case is adjourned to after summer vacation. Yes.
Bail application is pending.
Bail application is kept pending after summer vacation. If you insist, I will reject it. Will reject the bail application. Yes, okay. Next.
Item 9.
Yes.
Please, Your Lordship. Your Lordship, we have a pending bail application. However, we are seeking adjournment, Your Lordship.
You want adjournment?
Yes, sir.
You are appearing for the informant.
Not the informant, Your Lordship.
Author of the
victim fine. SC/ST. Land counsel for the appellant 6 for an adjournment. जो IA number लिख देवे 1105 of 2024. So it को adjourn कर दिया. Have you any objection about the stay of realization of fine? No objection. Stay of realization of fine allowed. No? Yes, next question.
Item 10.
Notice was on previous date.
Hmm?
notice
Well, he has already appeared. You are appearing for this.
Informed order type करें नहीं जो अपील मेमो सर्विस सर्व करते हैं तो informed judgment है
Criminal appeal trial court judgment देना थी. No, counsel को देना थी इसे बोलते हैं.
The informed judgment is not
Give him a copy of the informed judgment. You can take off next week, है ना? Extra copy अच्छी अपन पा रहे. They will hand over कर दो. IA number so and so. This is an application for bail and counsel for the state submits that he has not received the copy of the impugned judgment. And counsel for the appellant supplied the supplied the judgment copy to the land council for the state with this matter on 3rd of April 2024. Along with CRL number 1364 of 2023. What is your name? You have got the power. Amitabh Tripathi एके बेरा ना लिखाइए.
Associate.
अच्छा. सौभाग्य लक्ष्मी पटनायक. सौभाग्य लक्ष्मी पटनायक for the victim code. Victim. Yes.
Item 11.
କେବେ କୁ ଚାହୁଁଛନ୍ତି? Next week. You have got the deposition copies with you? Nine. You supply the deposition copy also in the meantime to the state council. Look on. What is your good name? Click in the so and so 6 for an adjournment. Upon power अच्छी case रे. Appearing on behalf of you are appearing for Lakshminarayan Patel. 6 for an adjournment. Acha. For an adjournment, leave this matter to for a 7th April 2025. Let the deposition copies of the witnesses be supplied to the land and council for the state in the meantime. Deposition copy सब state council को दे देवे आप इधर ना 7 तारीख आसियो मैटर 7/4/2025 रे. Yes.
Item 12.
Yes, Mr. Albrecht.
The appellant has been convicted under section 302 by 201 by 120 minutes.
Eyewitness to circumstantial evidence.
Only circumstantial evidence they have been implicated in that. There is no
Circumstantial evidence.
Yes, sir.
You are for the informant.
No, my lord.
Another co-appellant. Second item.
Connected appeal. So what is the case of the prosecution?
On 19/10/23 the deceased was missing. On 22/10/13 the FIR was lost to the missing of the deceased. And 2/11/13 the it was recovered from the jungle. After 15 days of the occurrence.
2/11.
2/11/13. Okay,
yes.
And 27 recovery of the dead body of the deceased that has been demolished by CW3 and 23.
No. What are the circumstantial evidence against you?
Last scene together,
Last scene. Who has stated about that?
That witness was found hostile.
Who are they?
That is PW 24 minutes. PW 25 minutes.
PW 25 is the sole witness to the last scene.
Yes, sir.
He has not supported the prosecution.
Yes, he has found hostile.
Okay, what else is there?
Except the PW 3 and 23. But police constables, they have stated at the time of the dead body is recovered.
PW 3 and PW 23.
The other villagers were at the spot. Before the recovery of the dead body of the deceased.
That recovery was made at your instance.
Yes, sir. Prior to that recovery, other villagers were there at the spot. They are present.
Okay, the recovery of dead bodies. Anything else?
No. That was
where dead body was recovered?
Jungle. And which one of offense?
After 15 days.
Yes, my lord.
Yes. Anything?
My lord, another thing, my lord, CDI report for the conversation between the petitioner and the deceased, my lord. On that is, my lord, on 19/10/23. And prior to that, my lord, the petitioner, this is as, my lord, they have talked together for various times, my lord. Not the first time she has talked.
What was the nature of conversation?
Regarding that, my lord, only he has asked to come to this place and to the bus stand, my lord. And from the bus stand, his motorcycle was missing on 19/10. And 2010, my lord, the FIR was lodged regarding missing the deceased, my lord.
No, the recording of conversation was produced, or just that data to show that this much of time they talk with.
That no certificate was given by the expert, my lord, only that is produced by the that much.
IO can't produce kala.
And it's a conversation that is
You recording the audio yeta jota.
Recording only my call details, my lord, not
call details ରୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି କଥାବାର୍ତ୍ତା କଣ ସେଟା କେମିତି ଜଣା ପଡୁଛି?
ଏଇ ଫୋନ କଥା ହେଇଥିଲା
ନା ଆପଣ ସେଇଥିପାଇଁ ପଚାରୁଛି, what is there any evidence about the nature of conversation? ଆପଣ କହୁଛନ୍ତି ଏଠି ଡାକିଲା ତ ଖାଲି କହିଯିବ ଯେ ଏଇ ଫୋନରୁ ସେ ଫୋନ କଲ୍ ଯାଇଥିଲା ଏବଂ ଏତିକି ସମୟ ସେମାନେ କଥାବାର୍ତ୍ତା ହେଇଥିଲେ। So what is your reply in your 313 statement that a question put ହେଇଥିବ ଆପଣଙ୍କୁ ଯେ ଆପଣ ଡିସିଜ୍ ସାଙ୍ଗରେ ଏଇ ଦିନ ଏଇତିକି ସମୟ ଧରି କଥାବାର୍ତ୍ତା ହେଇଥିଲେ ଘଟଣା ଦିନ ବା ଘଟଣା ପୂର୍ବ ଦିନ? What is your reply? କଣ କହୁଛନ୍ତି? ଆପଣଙ୍କ ଫୋନରୁ ତା ଫୋନକୁ କଥାବାର୍ତ୍ତା ହବାର ପ୍ରମାଣ ଆସିଲା CDR ରେ, କଲ୍ ଡିଟେଲ ରିପୋର୍ଟରେ। What is that CDR? That must have been marked or Exhibit 8. 18. So what question has been put on Exhibit 18 in your 313 statement? What is your reply?
Statement is not 18.
Conta nine. Accused statement 9. Accused statement no na ke mana ko. You collect it in your pen drive, go through it. Number of answers have been given. That would be very relevant, because the circumstances in a case of circumstantial evidence, when the circumstances are put to you, you are to explain those circumstances. जदि आपण घटना दिन डीसी संगे कथबार्ता हेतिले बोली गोटे आसुची, आपन जदि से विषय प्रथम क्वेश्चन हेछि ना नाही, जदि क्वेश्चन हेछि व्हाट इज योर रिप्लाई? कारण केते गुडा को देख सारलिनी मिछ कथा कहूनी, केते गुडा जिंस से रिप्लाई देछि तार माने ये। So you go through it and see that in what way. So these are what else is there? CDR. Last scene
has been not mentioned, but that has not been established.
Recovery of the dead body at your instance deposed to by 3 and 23 after 15 days. Anything else?
This was my lord.
Recovery of dead body, recovery of weapons.
So that has not been seized, no.
Weapon 9.
Not been seized. 9, not been seized. No weapon offense, no phone, mobile phone was
mobile phone da joti jo gadi ko pocket mein chaka jo se identify
not been seized.
Acha, have you obtained the criminal antecedent?
No.
During trial, he was on bail warrant by the family. Both the appellants.
No, that's the what question number 55 रे कहूची जेल में मेरे को मालूम हुआ कि मेरे नाम पे ये स्वान छो तामने गोटे केस रे बोधे से कहूची मुडा और केस रे कोन ए टाइप रो कोन नहीं चिपली। So you obtain the criminal antecedent also, and you collect this 313 statement through your pen drive if it is available with you, and go through it, and we'll take up this matter.
My case
ଆସିବ ତ ଏକା ସାଙ୍ଗରେ ଆପଣ ସେଠୁ consider ହେଇକିନି verify। No, एका साथ विचार हो आपण पाइबे कि नाही नॉलेज सेटू कहि देबे को मु कर देली बेल ता कर पाइलेनी सेटू फ्री ट्रांसफर हो आपण yes the land council for the appellant submits that he is not having the accused statement and he may be supplied with the accused statement in his pen drive. Let the accused statement be supplied in the pen drive once on being produced. Land counsel for the state shall obtain instruction about the criminal antecedent, if any, against the appellants. Vishwaranjan Gupta, so also Situ Panda. ଆପଣ କେସରେ ବି ଜଣେ appellant ତ?
both have convicted.
ଆଚ୍ଛା ଏଇଟା 7 ତାରିଖ ରଖୁ ଜାଣନ୍ତୁ ହଁ ଆଜ୍ଞା 7/4/2025 yes
Item 13.
The appellant before election was seeking an interim bail application, my lord. Interim bail application, my lord. IA number 599 of 2025. On the ground of my mother's illness, my lord. Health ground.
ଆଗରୁ ଆସିଥିଲା
No, my lord.
ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି
My lord. And interim application of first time.
ହଁ ସେ ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ପ୍ରେସ୍ କରି ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିଛନ୍ତି ନା ନାହିଁ ଆଣନ୍ତୁ ଆଇଏ କପି ଅଛି ଆପଣଙ୍କ ପାଖରେ आइए 599 of 2025 interim bail mother copy ଗୋଟେ ଦିଅନ୍ତୁ IA number 599 of 2025 this is an application for interim bail on the ground of ailment of the mother
My lord.
ailment of the mother of the petitioner have you annexed any medical documents
Yes, my lord.
medical documents have been annexed to the interim application get a copy of the interim application along with the medical documents be served on the land council for this
today.
अच्छा ମୁଁ ଖାଲି ଆମେ land council for the state shall obtain instruction on the same also the authenticity of the medical documents put of this matter on 7 तारीख ଆସିବ 7/4/2025
Item 14.
yes
CG case and the appellant was convicted on section 302 and life imprisonment along with fine and also on section 4 of the Prevention of the Witchcraft Act.
ପାଇଛନ୍ତି deposition copy ଅଛି
Deposition
ନାହିଁ ନାହାନ୍ତି ଦେଇଦିଅନ୍ତୁ next week land council IA number sponsor is an application for bail land council for the appellant supply the deposition copies of the witnesses examined in the trial court the land council for the state in court today put of this matter on 3 तारीख ଅଛି 3rd of April 2025 yes
Item 15.
And it seems that Bolangiri police PS case number 258/24 my lord. 14.
comprehensive affidavit not yet filed ଲେଖା ହେଇଛି
I filed once.
କେବେ ଫାଇଲ କଲେ
It's filed on my lord 19/3 my lord. With the receipt is there.
କପି ଦେଇଛନ୍ତି
Copy I have already stopped. File a copy my lord. It's a copy.
no ଫାଇଲରେ ମଧ୍ୟ 19/3 ରେ ଫାଇଲ କଲେ ଟ୍ୟାଗ ହେଇନି ଆପଣ ପାଇଛନ୍ତି ତ
ନା କପି ନାହିଁ
ତାର ଯୋଉ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଉପରେ
I have already given the
ଆଚ୍ଛା
copy. ବଲାଙ୍ଗୀର କେସ୍ କମ୍ପ୍ରେସିଭ୍ ଆକ୍ଟିଭିଟି not reached.
ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ ଆମ ପାଇଁ ପୁଣି ଜଡ଼ିବ land council for the appellant submits that as for the order dated 3/3/2025 he has already filed the comprehensive affidavit let the registry place the comprehensive affidavit on record stop comprehensive affidavit shall also be supplied to the land council for the state this matter 3 तारीख आंटी 3rd of April 2025 yes
Item 16.
CRM appearing item 2 and 4.
Item 16 Miller. In this case, first now we have received the brief Miller because of the earlier Mr. Naik with the petitioner counsel, so he has handed over this brief. So I pray let it come next week so that.
All right. The Land Council for the state seeks for an adjournment till next week. Put up next week, 7 तारीख also 7/4/2025. Yes. गोटे मैटर लिखी देबे आदर लिख देबे along with CRLA number so and so faster लिखी देगी. Yes.
Item 17.
Item 17, my lord, for a short adjournment.
What is your good name, Land Council?
Agnihotra Sahu, madam.
A.H. Sahoo.
A Sahu, madam.
A Sahu. नहीं, इधर लिखा है जी A.H. Sahoo.
भूल से ही है पर आइटम में
पूरा नाटक कौन?
अग्निहोत्र साहू, madam.
अग्निहोत्र साहू.
You are mentioning about CRLA number 1198
and 1198.
Both,
madam.
All right.
My learned senior would appeal.
All right, Mr. Sahoo, Land Council seeks for an adjournment. Place this matter in the week. 7 तारीख रख ले चढ़ो.
आपके early
रख ले. 15th.
Early, madam.
Early रख. Now next week तो what is दिन छुट्टी है, so let it come on 7/4/2025. Along with it is fast like along with ASIO CRLA number 1198 of 2020. ठीक है? Yes.
Item 18.
24/1 notice was gone to the informant. The informant is absurd.
Appearing for the informant. Personally, direct a copy may be some.
अपील में कॉपी देई ना दी
No, no.
अपन केमती अपील कले नोटिस रे
Notice जाइए.
दियन तांग गोटे कॉपी दियन अपील में मोर and along with the interim applications for bail and stay realization of fine.
Deposition copy also not so.
In the meantime, I will solve the deposition.
Listen, what is your good name?
Khageshwar Behera.
Huh?
Khageshwar Behera.
Khageshwar Behera. Mr. Khageshwar Behera, Land Council for the informant, submits that is not having the copy of the appeal memo, also the interim applications for bail and stay realization of fine. Let the Land Council for the appellant supply the same to the Land Council for the informant. Land Council for the state submits that he has not received the deposition copies. Let the Land Council for the appellant supply the supply the deposition copy of the witnesses to the Land Council for the state. Put up this matter on 7/4/2025 with CRLA number 1336 of 2020. Yeah, next.
Item 19.
Therefore, the case of adjournment.
Akshay Kumar Sangh ko kahin adjournment मांगते हैं. What is your good name?
My name is Smriti Ranjan Rao.
You have got no power in this case.
No, sir.
Smriti Ranjan
Rao, R.A.O.
R.A.O. Mr. Smriti Ranjan Rao appearing for Akshay Kumar Sahoo, advocate, 6 for an adjournment. This matter, 7/4/2025. Yes.
Advice.
Item 20.
My lord, prayer for bail, IN number 848/2025. Appeal against conviction for life imprisonment for life for the offence committed under section 302.
Deposition copy पाइछन copy दियो तो deposition copy. Land Council for the appellant, Miss Binapani Tripathi, supplied the deposition copies of the witnesses to the Land Council for the state in court today. Dilata, who seeks some time to go through the same, place this matter on 7th of April 2025 for consideration of the interim application for bail and stay realization. Okay, possible.
The conduct